In today's video, is the University of Idaho and the court system hindering justice? Well, the Goncalves family certainly thinks so, and that's exactly what we're going to talk about today. And if an open conversation is something you prefer, then this is the place for you. Welcome to The Point, so let's talk about it.
Copyright disclaimer under Section 107 of the Copyright Act 1976. Allowance is made for fair use for purposes such as criticism, comment, news reporting, scholarship, and research. Fair use is a use permitted by copyright statute that might otherwise be infringing. Nonprofit, educational, or personal use tips the balance in favor of fair use.
A few days ago, the Goncalves family made a post on their Facebook page, pretty thoroughly laying out the reasons why the home should not be demolished. And towards the end of that post, there was a sentence they used that brings up a bigger question. And what they said specifically was this: "We feel the University of Idaho and the court has put us in a horrible position to have to voice our opinions. So is the University of Idaho and the court system hindering justice?" And when you look at the University of Idaho, are they suggesting in that post that the university has been consistently working against them while they try to get justice for not only their daughter, but the rest of the victims? Or are they suggesting the University of Idaho is trying to hide the truth? On the surface of it, the logical reason they are making these statements you would solely believe to be tied to the home. And they are in the belief that that home is an absolute key piece of evidence. And for the record, universally, regardless of where you were falling within this particular case, almost everybody who has followed this case from the beginning has believed that that home offered key evidentiary value. But the university has felt differently about it. In a previous video, we went over the comments of the president, where he essentially said that he thought that the home had sentimental value to the victims' families, but it was time for it to go, and made no reference to its evidentiary value. And we know about those 3D scans that are supposed to be able to perfectly lay out the home and give a potential juror each and every single piece of information they could possibly want. But I would also wonder if there is something more to this beyond the actual home standing. We know when it failed, they were probably devastated and heartbroken. But with such a strong statement, are they also implying that there has been other things throughout the handling of this case that they felt the university had done wrong, or they had felt a lot of pushback from the university? Now, if there was something going on behind the scenes, I'm definitely not aware of it, and I don't know if any of y'all are aware of it either. A lot of us do assume that the Goncalves family knows a whole lot more about what evidence the state has than the general public. And I would wonder, in terms of the strength of the overall case, for them to view this home as such a crucial piece of evidence, is that an indication that the other evidence available may not be as strong as what a lot of people believe? But how do the courts tie into this particular comment? Because they have alluded to the fact that they feel the court is not doing its job in pushing this case forward. They did make references in that post to the delays in the indictment, and the delays tied up with that investigative genetic genealogy, and that we're still waiting on that in-camera review. And who is to blame in this whole process? Well, naturally, the individuals when this wind blows, we'll get back to it. And who is to blame for all these delays? Well, you'll have the individuals who believe Bryan Kohberger is guilty of this crime will say that these delays are strictly the fault of Bryan Kohberger's defense. That they're asking for too much discovery, that they're fighting over everything, that they intentionally were going to waive his speedy, and everything they're doing now is just a stall tactic. But I would urge everybody to keep in mind a couple things. Remember that there is a whole bunch of these discovery requests still floating out there that haven't been resolved. Now, whose fault is that? Is it the defense's fault for asking for discovery when representing a client? No, that is their job. It is the prosecution's job to give that discovery to the defense. And the defense can't do anything other than fuss and bring it up in hearings what they're still missing. That is all they can do. They cannot force the prosecution to stop what they're doing and turn that stuff over. So there are aspects of this delay tied to the prosecution. In terms of the investigative genetic genealogy, that is also not the fault of the defense. They've had some questions about what the investigators used to tie all this evidence to Bryan Kohberger, and the investigative genetic genealogy was one of the building blocks or tools, however you want to phrase it, used to link Bryan Kohberger to this crime. So that stuff did need to get turned over, and that was a huge fight, and that was a huge delay. There was the big hearing on it. We've heard back and forth discussions over it. So to simply blame that on the defense is also incorrect. And what is the court's job in terms of speeding all this up to get it to go to trial? As frustrating as it may seem, I do still feel like the court as a whole is doing everything in their power to keep this trial on track, regardless of the appeals and how everybody feels about them. The defense has rights. The accused has rights. And they certainly don't feel like there is something within this grand jury indictment that was fair. Now, what it is, we don't know because all that is sealed. And before people think the defense is just making things up to stall a trial, or they're simply trying to run up a bill that the taxpayer will have to pay, keep in mind what would happen to an attorney if they were intentionally trying to file paperwork they knew had no bearing. If that were the case, they would run the risk of fines or even possibly being disbarred, not to mention they would be pulled off the case. So to simply say that all this is being pulled out of thin air and it has no bearing whatsoever is not correct. I know it is frustrating for the family. It has to be frustrating for the family. They want justice far more than any of us would want justice. Now, whatever hand the university is playing in terms of hindering this overall investigation, we will have to wait until the trial to see. We will ultimately find out at trial if the home should have been left standing. And time will tell where the university falls in terms of justice. We don't have all the facts yet. We don't have all the evidence yet. I would assume it is normal for people in their particular position to be frustrated with the judicial system, but that isn't also all the defense's fault either. The prosecution has had plenty of time to either produce this discovery or produce some type of documentation validating that that particular piece of discovery does not exist, and they simply haven't done that. And that isn't just me speculating. You can go back to the actual hearings, and when the prosecution makes the statement that they don't have it yet, they'll reach out to whoever to go get it and see if it's available. The judge tells them that's probably a wise move because they should have done that from the beginning. None of these discovery requests, especially very early on in these pretrial hearings, were a surprise to the prosecution. They just fought tooth and nail on several of these and have been a contributing factor in the overall delay of the trial. Now, if you see any of this differently, you can let me know down in the comments below. Other than that, I appreciate your time. I appreciate you being here. Y'all stay safe. I'll catch you in the next one.